All right, I think we're ready to begin. Welcome, everybody. Thank you for joining us today to discuss the Corporate Transparency Act. I know most of you are accountants or financial planners or other professionals who have clients who might be asking you or probably asking you about this act. This has kind of hit us all rather quickly. And there's a lot of uncertainty about what to do and when to do it and what the penalties are. So we are fielding a lot of questions from our clients and trying to be proactive in contacting them and letting them know what they need to do. And I'm sure you're doing the same. And it probably doesn't help that it's tax season and you're starting to see clients as they come in. And this is probably a point of discussion, or maybe should be, as you're meeting with your clients. So we're going to do our best today to explain the act. We've got an hour. We're going to try to explain the act in a way that will help you with your clients and with your own businesses, and give you some pointers. We're going to save some time at the end for Q&A. This will all be through the chat. Obviously, you're going to submit your questions in writing. We're probably not going to answer questions as we're going along. We'll wait till the last 10 minutes or so, 15 minutes to answer questions. So feel free to submit questions whenever you like. And I think we probably are going to go over a little bit at the end if we have a lot of questions. Those of you who need a hard stop at 3, I totally understand. You can check out then. But we will allow enough time for questions at the end. So the Corporate Transparency Act, this is an act, you've probably figured out by now, affects small businesses disproportionately. Larger businesses are exempt, which is a little backwards from what we're used to. Usually smaller businesses are exempt. So there's a huge burden on small businesses to comply with this act. The penalties are severe, $500 a day for failure to comply, and possibly 2 years in prison if the non-compliance is willful. The purpose of the act is to provide information to law enforcement, national security, and other government agencies and some other third parties to prevent money laundering and terrorism. So what the government is doing is they're looking for the real people behind the businesses, these small businesses. Smaller businesses tend to be the ones who are engaged in money laundering and setting up dummy companies. They're looking for those, the actual flesh and blood individuals who are controlling those companies and or who own those companies. So the question probably comes up to a lot of you: why are we expecting the bad guys to file these forms? They're not going to file them. It's the good guys who are going to file the forms, and they're not the ones the government is targeting. So it's a little backwards. Well, that's kind of the idea. I think what the government is doing, we view this as maybe kind of a RICO act. What the government is doing is looking for those who aren't filing the forms. And when there's an arrest or an investigation and they find a company, this is an easy conviction. This is an easy 2 years in prison for somebody who's on the wrong side of the law, and the government needs to convict them. But it's harder to convict somebody of money laundering than it is the failure to file these forms. With that said, no, they're not after your clients. They're these millions and millions and tens of millions of these forms are going to be filed this year and going forward. So the government doesn't have time to look over those forms. I think they are truly using this as a tool of enforcement. So the other thing I wanted to point out is that there's a lot we don't know yet. There are a lot of unanswered questions as we look through the law. We start to fill out these forms. We still have unanswered questions. And so you'll note as we go through the slides, we may not have all the answers. We're all kind of in the same boat there. We're waiting on some more guidance from the government. This website only got launched on January 1. So we'll be waiting for more guidance. We will keep you informed as we learn more. Most companies the companies that already existed as of January 1 have until the end of the year to file. Of course, you don't want to wait till the end to do that. The new companies have 90 days to file. So I think we'll probably learn more as the year progresses. So anyway, I'd like to introduce our panelists. I'm Jeff Agnor. I'm one of the partners here at Davis, Agnor, Rapaport, and Skalny, and I work in the corporate and transactional practice. My colleague Chris Walter is an estate planning attorney. He heads up our wills and estates practice. And as we go along, you'll see that the CTA affects trusts in big ways. So our estate planning folks are just as concerned about the CTA as the business attorneys. And then Matt Speak is my colleague he works together with me in the business and transactional practice. So Matt, I'm going to hand the slides over to you, and if you could give us the background on the CTA, please.
Yeah, thank you, Jeff. And that was a great overview. And I think you touched on a lot of these points already, but we'll just kind of reiterate this. The Corporate Transparency Act was included in a piece of legislation that was passed in 2020. So it's been hanging around for a little while. Over the past few years, there have been some refinements to it, a few adjustments. There was a rulemaking process. But what matters now is the Corporate Transparency Act's beneficial ownership information reports that we're going to talk about extensively in this presentation. And that really went live just this past January 1st for certain entities. And we'll talk extensively about the timing requirements, and they are pretty nuanced and require a delicate analysis. So we'll be sure to cover that. As Jeff mentioned, the purpose of this law, the stated purpose, is to provide information to law enforcement so they can determine the flesh and blood owners of various entities. And look, on its face, that sounds noble. It sounds like a great idea. However, as we've been reviewing the legislation and the regulations, we're finding that it's fairly vague. It's tough to pin down some of these terms. And the devil's really going to be in the details on how this is implemented. And we're afraid that the way that it's structured could create some traps that people will unwittingly step into. So that's one of the reasons we felt it was so important to provide this presentation and a little bit of education on this topic. The agency that's in charge of this program is the Financial Crimes Enforcement Network. It's part of the Department of Treasury. It's a relatively small agency, but it has been empowered with taking on this task. Let me slide to the next slide, please. Great. So as I mentioned, the core component of the Corporate Transparency Act that we're concerned with today are these beneficial ownership interest reports, BOI reports, we call them for short. So the question is, who needs to file one of these reports? As Jeff mentioned, the analysis is a little bit counterintuitive. We're used to small businesses being exempt. That's not the case here. This is a very broad definition of companies that need to report. So we're going to start with anything that files a document with the Secretary of State. So we're talking corporations, LLCs, limited partnerships. All of those classic business entities are going to meet this initial determination of a reporting company. FinCEN's own estimates have pegged the number at about 32 million companies that are going to have to file this year. And then every year thereafter, there will be 5 million additional companies. And that's just the initial report. As we'll talk about, there's additional updates that need to occur upon various events that happen on a very irregular basis. So the total number of reports is going to be massive in this for sure. All right, so we have that broad definition of reporting companies. There are some exceptions. There are 23 different categories of entities that will not need to file these reports. They're generally companies that are already subject to outside regulation. Things like banks, public accounting firms, if they're structured and enabled under the proper provisions, tax exempt entities. The two that we're most concerned with here are going to be the large operating companies and dormant companies. Our analysis shows that those will probably be the largest buckets that exclude entities from reporting. But even in those cases, the analysis is fairly nuanced. We have to look at specific factors to make sure that the companies qualify as large operating companies, dormant companies, or any of the 21 other exemptions that may apply. All right, so if we've determined we have a company, it's not exempt, it's going to have to file a report. What information do we have to file with the government? So there are three components to these BOI reports. The first one is the basic information on the reporting company. Go ahead and advance to the next slide, please. This basic reporting company information is the very, name, rank, serial number, very high level information, the name of the entity, any trade names, the principal place of business, the tax ID number. It's usually going to be an EIN. For entities that wouldn't ordinarily get an EIN, they're probably going to have to get EINs now in order to satisfy this reporting requirement. And then you'll have to list where the entity was formed. The second component of the report is this applicant information. It's the company applicant. This is the individual who actually submitted the paperwork to the Secretary of State to form the reporting company under this program. Not only the individual who filed it, but also anyone who directed it. So in our practice, we'll often have clients come to us as attorneys and say, I want to set up an LLC. We'll walk them through the process. One of the paralegals at our firm will help execute that. In that scenario, both the attorney who supervised the work and the paralegal who submitted the form would have to submit their information as a company applicant. The information that has to be reported includes the full legal name, date of birth, residential address, and an electronic copy of an identifying document, so a driver's license or passport. So we've been working through this program. We have had to submit, as attorneys who form entities, pictures of our driver's license to the federal government in order to satisfy this requirement. Now, there's a note here at the bottom of this slide that talks about a FinCEN ID. We'll discuss that a little bit later through the presentation, but there's a way that you can receive a unique identifier from FinCEN that you can use to supplement some of this information in the future. And the final phase is the most complicated, the most involved, and it's information on the beneficial owners. I'm going to turn this over to Jeff so he can walk you through how this analysis works and who might be included here.
Sure. Thank you, Matt. So this is what the form is all about. The beneficial owners. It's called a beneficial owner information report, BOIR. So the beneficial owners are those flesh and blood individuals that the government is trying to ferret out. And they use a very broad definition of beneficial owners. We're not only talking about owners, we're talking about those who own or control the company. And throughout the regulations, the term directly or indirectly are used. So a beneficial owner always has to be an individual, first of all. It can't be another company. And it's someone who directly or indirectly either owns at least 25% ownership interest in the entity, and we'll get to what that means in a moment, or they exercise substantial control over the reporting company. And again, that's a directly or indirectly. So for example, if the company, the reporting company, is owned by a parent company 100%, and then that parent company in turn is owned by two individuals, and those individuals own more than 25% or control the parent company. If they indirectly through the parent company control the subsidiary company, then you have to report them as beneficial owners. So no, they don't directly own and they don't directly control perhaps the subsidiary company, but they do control the company indirectly through the parent company. So in other words, the government is peeling back the onion, the layers of the onion, and going all the way up to the top until they hit flesh and blood owners who are in control. So the beneficial owner must be an individual. Examples of somebody who has substantial control would be a senior officer, certain board members, and so forth. So for these beneficial owners, on the report that the company, the reporting company files, the beneficial owner information report, the information concerning these individuals would include their full name, date of birth, residential street address, a unique identifying number. In this could be a driver's license number, or a passport number, or a similar document, and an image of that document. So a photograph of the driver's license or the passport. Interestingly, you do not report the social security number of the owner. And so I believe the government believes that a driver's license is a better evidence of who individuals are, or a passport, because when the driver's license or the passport was obtained, a birth certificate probably had to be presented. So they believe that's very valid and sure evidence of who the individual is. So that information has to be provided. As an alternative to filling out all that information on the form, the individual owner, the beneficial owner, can obtain a FinCEN identifier. It's a number, a FinCEN ID number. And when you apply for a FinCEN number, you have to provide all this information to FinCEN. FinCEN is the Financial Crimes Enforcement Network. It's an agency or a bureau of the Treasury Department. It's a sister agency to the IRS. It's not the IRS. It's not affiliated with the IRS. It's a separate agency. So you can go in and get now a FinCEN number. All of us have FinCEN numbers. The beneficial owners of the companies can get a FinCEN number. And then when the beneficial owner report is filed for the company, all they have to do is enter the FinCEN number under this section on who the beneficial owners are. So if you have multiple beneficial owners, you just provide all the FinCEN numbers. So more importantly, if an individual owns multiple companies and is the beneficial owner of those multiple companies, the FinCEN number can be provided on the reports for each of those companies. And then the law does require that the company keeps up to date the beneficial owner reports, information reports. So if there's a change in any of this information, the legal name, date of birth, Matt brought to our attention that the government wants you to change, to notify them of any changes to your date of birth. And we're trying to figure out how you would do that. Residential street address, or your driver's license number. If there are any changes to any of that information, the beneficial owner's information report has to be updated. So if the owner has a FinCEN ID, if that number has been entered into the report, they simply have to update their FinCEN ID with FinCEN, and that will then populate all of the reports. So you don't have to do it one time. So especially for owners with multiple companies, it's a good idea to get a FinCEN number. It's not terribly intrusive. It's easy to do. We're recommending our clients all get FinCEN numbers if they're beneficial owners. Okay, next slide, please. So the first test is control. In determining whether an individual is a beneficial owner, the first test is ownership. They own directly or indirectly 25% of the ownership interest in a company. And that would include, the ownership interest would include typically what you would expect: stock of a corporation, an equity interest or a membership interest in an LLC, or similar interests. It also includes, and this would apply to LLCs and partnerships, a capital equity interest or a profits interest. So even though a profit interest might not have a capital account associated with it, profits interests are included in as an ownership interest. It also includes convertible debt. So if someone has a promissory note with a convertible feature, that they can elect to convert the note into equity, that note, the amount of equity into which they can convert that note, is considered owned by them, even though it's a possible future interest that they don't own currently. Same goes for Stock options, calls, puts. Again, it's the right to own equity in the future upon exercising that interest. They don't own it currently. So in other words, it's the fully diluted value or interest in the company as if all of these rights had been exercised. And that's how you treat it. You treat it as if all those rights had been exercised, and then you determine kind of the denominator. And by the way, there's some great guidance in a booklet that the government gives you, the Small Entity Compliance Guide. There's some great guidance on how to do the math on this and do the calculations. And we don't have time to go into great depth on that here, but basically the denominator would be, for a corporation, all of the outstanding stock and all the outstanding stock options and convertible debt and so forth. The numerator would be the particular beneficial owner's stock, options, and convertible debt. For an LLC, it would be, of course, the denominator would be all the actual interest, capital or profits interest, and again, any options. And the numerator would be that individuals. So again, it's the fully diluted interest in the company. And then finally, here's the catch-all. There are a few catch-alls in the regulations where if you didn't fall into one of these categories for some reason, if there's something else that creates ownership, some document, some contract, arrangement, understanding, relationship, or mechanism, how broad is that? The FinCEN can consider that as ownership. What this does not include, unless we get further guidance in the future, what this does not include is synthetic equity or phantom stock. That is in the form of compensation. That is not ownership. So we would not include that as ownership. The other way to determine if someone is a beneficial owner, they may not own 25% or any equity in the company, but they have substantial control over the company. And the categories are these: anyone who is a senior officer is automatically considered a beneficial owner. They have substantial control. What does that mean? That means the president, all the C-suite, CEO, CFO, COO. I would say it would include an executive vice president. That's not an exhaustive list, but the typical executive officers of the company also would include senior counsel for the company. General counsel for the company. We're not viewing that. We represent many companies and have for many years. We're their go-to counsel. Colloquially, we might refer to ourselves as the general counsel, but that's not a position in the company. So we're viewing that as someone who's on the inside. Another category is anyone who has the power to appoint or remove a senior officer or a board member, or a majority of the board. So that would typically be, but not always, that would typically be somebody who owns a majority of the voting stock of a company. That would be for a corporation. Or if somebody is holding a irrevocable proxy or a voting trust, they have the right to cast that vote. They might also have that power to elect and remove a senior officer or a majority of the board. By the way, what's missing here, you'll see, is the word director, somebody who's on the board of directors. We're not viewing that somebody, in fact, it's in the Q&A provided by FinCEN. Someone who is on the board of directors is not automatically a beneficial owner. Even though the board manages the company, individual board members don't make decisions. They don't have power. They can't sign contracts unless they're authorized to do so. Boards speak and make decisions as a group, collectively. So someone who is on the board of directors unless there's something else going on, they're not automatically a beneficial owner. They may be a beneficial owner for other reasons. They might also be a senior officer, but by virtue of being a board member, they're not automatically a beneficial owner. And then someone who has substantial influence over making important decisions. And this would include major decisions, sale, lease, transfer of the company's assets, the principal assets, merger, dissolution, major contracts, product lines, getting in and out of product lines. So those again, it's kind of a catch-all. There's a catch-all within that catch-all, but these are people that may not have a formal position in the company, but they have substantial influence over major decisions. Would not include a trusted employee who everyone listens to, who may have a lot of influence over decision makers, but they're not decision makers. They're just employees, and they don't have authority beyond that. They would not be considered beneficial owners. Okay, I think we're ready for the next slide.
So this is where we're getting into the trust world, because trusts can be beneficial owners. A trust can own an interest in a company that would otherwise be reportable. So there needs to be an analysis of who actually needs to report as a beneficial owner and under what circumstances. So first, it's important to note that most trusts themselves are not reporting entities. If you remember from the first couple slides, the trigger to be a reporting entity is you need to file something with the Secretary of State or a similar office. Trusts typically don't file anything with the Secretary of State. I think there are a couple states where they might, and certain business trusts do, but your plain old ordinary trusts do not. However, the trustee is a reporting person. They are a beneficial owner, so they're going to have to have their personal information on that BOI report, and certain beneficiaries are going to be beneficial owners. So if they're the sole permissible recipient of income or principal, if they can demand distributions, or of course, if it's a revocable trust and it's just in there for probate avoidance purposes, then that person is also going to have to report. Also, while this isn't explicit in the regs, it's pretty much accepted that most or certain types of trust protectors, depending on their authorities, might have to report. This would be under that substantial control prong. If they have the ability to appoint and remove a trustee, for example, then that might sweep them in. There are some exceptions for who has to report as a beneficial owner. Now, for example, a minor, they themselves don't have to report. Their guardian would, but the minor's information isn't going to be submitted. With some of these, there's going to be some analysis that needs to be done. So, for example, while agent or nominee is listed in the exceptions, if they're actually exercising their authority, for example, under a power of attorney, if they're voting the shares of stock, that might sweep them back in to become a beneficial owner that needs to be reported. Jeff mentioned employees of reporting companies typically don't have to report if it's a future interest, even if it's a vested future interest. And then by virtue of inheritance, they're going to be off the hook. And creditors, again, some analysis is going to have to be done on the type of debt. But if it's just regular debt, then the creditor is not going to have to report as a beneficial owner. All right, so we have a few case studies that we wanted to walk through to see this in action. The first is involving this universe of people. We've got ABC Incorporated, XYZ LLC, and Joint Venture LLC. And those are the players that we have. We can go to the next slide. All right. So in the first part of this case study, we have Joint Venture LLC is wholly owned by XYZ LLC. And XYZ has two members. We got Xander and Yvonne. Xander owns 30%, and Yvonne owns 70%. They are both going to be beneficial owners of both XYZ and Joint Venture LLC because they meet that equity test. They own more than 25% of the company each, so they're both going to be on there as beneficial owners. Now it gets a little more complicated when we have XYZ and ABC both as 50% owners of joint venture. So let's assume that same ownership for XYZ, it's the 70-30. ABC would otherwise be an exempt entity. They're a large corporation, etc. And they've checked all those boxes. So here, ABC is going to be owned 50-50 by Adam and Brienne. And Adam's going to be active in the business. He's the president. Chloe is going to be, and actually, I think, Brienne is the other investor. She's totally passive, silent investor, not really involved at all. And then Chloe, she's the vice president. She has no ownership interest, though. So we're looking at what needs to be done with each of XYZ, ABC, and joint venture. Well, Yvonne and Xander are still beneficial owners of XYZ. Yvonne, Adam, Chloe, and ABC Inc. are the beneficial owners of joint venture. And here's how this breaks down. Go into the next slide. So Yvonne's a beneficial owner of joint venture because she owns more than 25% of the equity. She had 70% of XYZ, which means she has 35% of joint venture. Xander only had 30% of XYZ, which means 15% of joint venture. So in this scenario, he's off the hook as a beneficial owner for joint venture. Now, while Adam and Brienne each own 25% of ABC Inc., there's an exception in the rules that if you're owned by a exempt entity, you can just report the entity itself. So you can fill out the BOI report and say, yep, ABC Inc. owns, would otherwise be a beneficial owner, and the analysis kind of stops there for ABC, but you still need to look at the substantial control prong. Adam and Chloe, remember the president and vice president, they can go in and exercise authority over joint venture LLC in their roles as the president and vice president of ABC. So they're probably getting reported as the beneficial owners of joint venture along with Yvonne. All right, and just to close the loop on this, so ABC Incorporated also owns 100% interest in QRS LLC. The answer here is an easy one. If QRS is wholly owned by an exempt entity, then it doesn't need to file. There's an exception in the rules for that one. All right, so that was case study one. We got another case study for you, and this is our universe of people. We've got Penny, Vincent, Greta, Debbie, and Tom. So going to the next slide. Let's say that Penny and Vincent, they form a corporation, that they're the board of directors and officers, but no stock's been issued from that corporation yet. And that's sometimes common, or we run into that sometimes because you might not know how the equity is all going to shake out, but you know that you need to spin up the entity. Well, even though there's no ownership interest being issued, there still are beneficial owners. It's the two people who can exercise substantial control over the company, Penny and Vincent. So they would go on that initial BOI report. So let's say 4 months later, the corporation gives 100% of its stock to a revocable trust with Greta as the grantor. Her revocable trust says everything goes to my 16-year-old daughter, Debbie, in trust when I die. Tom's the trustee of Debbie's trust. So on Debbie's death, down the line, her trust would go to Greta's favorite charity. So when that stock is issued, there's another BOI report that needs to go out. Greta, Penny, and Vincent are the beneficial owners Greta by virtue of her ownership of 100% of the stock, Penny and Vincent because they're officers of the company and can exercise substantial control. And that might lead you to ask the question, should Greta actually have been reporting on that initial report under that substantial control prong on the catch-alls for any other mechanism? If she's really back there pulling the strings and sort of directing the formation of this company, maybe she should have been on that initial report as well. Debbie is not going to be a beneficial owner that needs to be reported because her rights are only going to come through an inheritance. So going to the next slide. 5 months after that, Greta dies. Debbie's now 17. Greta's revocable trust is wound up and distributed to Debbie's trust. During the administration of the estate, nothing actually needs to happen. It just functions as it would have had Greta been alive. So there's no report that's triggered on somebody's death. It's only when the interest is actually distributed. But when it is distributed, there's going to be a BOI report listing Penny and Vincent, still the officers, Tom as the trustee, and Debbie's guardian as the beneficial owners. Then remember that Debbie, she's only 17 at this point. She's a minor. She does not need to be reported. She falls in one of those exceptions. And the charity is not listed because their rights only coming through an inheritance. So a couple other things happen. Debbie turns 18. Within 30 days, you have to fill out a new BOI report. Debbie renews her passport, and when you renew your passport, you get a different number. So if that's the number, if that's the document she used to fill out to be reported as a beneficial owner, if that's the scanned document that she submitted, well, she's going to have to resubmit with a new picture of a passport. Debbie moves, new BOI report. Again, all within 30 days. Then Debbie dies. So after the distribution to the charity, we're done. We don't need to report anymore because the business is now wholly owned by an exempt entity. But the company does need to file a report to inform FinCEN that it is now exempt. So those are a couple case studies. When to report, the timing of this. So for existing companies, if you were formed on or before December 31st, 2023, you have until 1 year, until January 1st, 2025 to report. Companies that are formed this year, January 1st, 2024 through December 31st, they have 90 days. Companies that are formed after January 1st, 2025, you only have 30 days to file that initial BOI report. And then after you filed an initial report, any of those changes need to be reported within 30 days of the change, which is a lot of overhead. I'm going to turn it back over to Matt now so he can talk about his favorite part of this, the penalties for non-compliance.
Thanks, Chris. Yeah, so as we've just shown, these are not necessarily easy determinations to make, and they change over the life cycle of an entity. So why do we have to comply, and why do we have to be careful and cognizant of all of those intricacies and developments? Well, it's because the CTA carries real consequences for failure to comply. Now, I'll tell you what we do know right now is that the way that the regulations and the legislation is written, for penalties to be imposed, the violations must be willful. So we think that means that unintentional, accidental, mistakes aren't going to result in these penalties, but they exist, and willful is, that's up to the determination of a judge or a jury one day. That's a scary place to be, right? We don't want to be dealing with that. So there's two types of penalties that can be imposed for failure to properly comply with the CTA. The first are civil penalties, and these go to $500 per day. So they start racking up quickly. And remember, this legislation targets small businesses. So, when we start racking these up, that can become a substantial number pretty quickly for, a little single member LLC somewhere. And then there are also criminal penalties they can fine up to $10,000, and they actually carry up to a 2-year prison sentence. Now, these penalties can be imposed on the company. In the case of civil penalties, that makes sense. Criminal penalties, you can't really put a company in jail. So the regulations provide that senior officers who also fail to willfully comply can be subject to the penalties as well. So, it's a very real possibility, as Jeff mentioned earlier. This may be a way for a prosecutor down the road to, use this as the violation that's easier to charge than something else. But there is actual prison time for willful failure to comply. All right, so when we generate these reports, where do they go? What happens, right? So now you go to a portal, you submit this information to FinCEN, it's going to sit in a database somewhere. The stated purpose is to provide law enforcement access to this information, and that's what we're seeing in the regulations, that federal agencies who are involved in national security will be permitted to access this information to ascertain who the ultimate owners are of these entities. There are also provisions that provide scenarios where state and local law enforcement can obtain the information. The IRS may be able to get the information for tax purposes. And there are even some circumstances where non-government agencies, where financial institutions would be able to access the beneficial owner report. Now, we believe right now that would only be with the company's consent. So you have a little bit of protection there. It would be limited in the government scope generally, but these are rapidly evolving, and we don't necessarily know where it's going to land. So it's something that we're keeping an eye on, tracking closely. And then obviously, once these databases are created, there's cybersecurity concerns as well. And this has some pretty sensitive information, as we've talked about. Home addresses and identifying documents, date of birth. So it's sensitive information. We mentioned the penalties for failure to comply with the BOI reporting requirements. The regulations also provide very significant penalties for abuse of the information that's provided, right? It's beyond the scope of what we're talking about today. But if there is misuse, there are also penalties associated with that. And I mentioned briefly, how to report. There's a website that's been spun up, as Jeff mentioned. It started at the beginning of the year, and you can log on. You can input the information. There's also a PDF that can be completed. It's pretty sophisticated document that walks through the various steps. The technical filing of the report isn't the big hurdle here. That's not the heavy lift. The heavy lift, as we've talked about, is determining who needs to report, and then staying on top of your regular updates upon changes of events. But going to the website, filling it out is good. Our experience so far is that the website functions well. As Chris mentioned a minute ago, we'll caveat that by saying that very, very few companies have had to report yet. Right, as the companies start to age, and as we start to get to the end of the year, and all of these historic entities will need to file by the end of the year, there could be some strain on this website, and we'll have to see how that plays out.
All right, so we wanted to leave you with some best practices that we're thinking about, that our firm is trying to implement as we're grappling with this law and how to move forward. So the first thing is, should our firm be responsible for filing? And when should we do the filing? So no matter what, we want to make sure that when we're engaging with clients, the responsibility for compliance is clear and in writing. When we are doing the entity formation ourselves, we think it's an important part of that work product that we are going to do the initial filing on behalf of the clients. But for the ongoing updates, beyond educating the clients, that's a pretty big ask to have our firm have responsibility for tracking when whatever beneficial owner happens to move in 15 years. We do want to give clients the counsel that they do need to have infrastructure in place to monitor the changes, and that there should be somebody responsible for doing these updated BOI reports. And while some of these are going to be on a regular cycle, so every year, you might have new directors appointed. That's something you can set your watch to. There's going to be other things that just come up in the course of life, and it's going to be something that we're going to have to just educate clients on staying vigilant about. In terms of how we're approaching things for this year for existing companies, while we don't want to push everything to the 12/31 deadline, there's still some guidance that we think is going to be important coming out from FinCEN, from Treasury, potentially from the courts, that we're taking a bit of a wait and see approach. We want to start gathering the information now that's necessary, but we're going to hold off on pushing that button and filing the initial BOI report. For new companies, it's within 90 days. So we're making the BOI reporting, getting that information as part of the intake process. It can't necessarily all be streamlined because the EIN, we're not necessarily going to have that immediately once the documents are signed. It might take a checklist and some followed up. So we have a tracking log that we've implemented to make sure that this isn't falling through the cracks. But that's how our firm is approaching doing the filings.
I think too, as if you are forming the entity, you are physically going to form the entity, file the articles of organization or the charter with SDAT. Then if your firm is doing that, then it's important that you make sure that you have the power, the authority to file the initial report with FinCEN. You get the client authorization to do that, and in your intake process, you've gotten all the information you need in order to fill out the form. And again, we do encourage our clients to get a FinCEN number, so that once you have formed the entity and gotten the EIN, no, you can't form, of course, you can't file the form, as Chris said, without the EIN. Once you've gotten that, you'll have all the information you need in order to file the initial report.
So in terms of what else our firm is implementing, first is general communication. So we put an article up on our website. We blast that article out to our firm's mailing list, doing educational pieces like this, just trying to get in front of clients generally to let them know, hey, there's a new law that may apply to you. We're updating our intake processes to make sure that as part of the engagement, we are getting the necessary information for the BOI report. We're looking at our engagement letters, looking at the terms of conditions in our engagement letters in terms of defining what the scope of the work is and making sure the responsibilities for reporting are clear. And then for our transmittal letters, if you deal with lawyers, we love those letters that, the CYA letters essentially, that lay out who's on first. And that's a great place to alert clients of their ongoing responsibilities, and what compliance means and what systems they should have in place for it. Other ways that we're looking ahead and sort of adjusting some of our processes. So as we've mentioned a couple of times, we think those FinCEN IDs are going to be a really big benefit. If somebody gets a FinCEN ID and that's what's reported either under the beneficial owner or for the applicant, you've shifted the burden from the company doing that tracking to the beneficial owner, to the person who has that ID. It's now their responsibility to update FinCEN instead of the company's responsibility to update FinCEN. So I think that'd be a huge weight off the company's shoulders. This is the time to be evaluating existing clients. While we can't always clean up the equity or ownership piece, the substantial control piece, we might be able to clean up. Is there that crazy uncle in Montana who's on the board sort of out of deference to their family status? Is that somebody who's going to want to report all their information to the federal government? Is the reporting company, going to be able to wrangle that information, and does not getting that information put the company into non-compliance? So before that reporting requirement is triggered at 12/31, this is the time to be evaluating those current companies. The single member LLC piece, this is some technical language in the regulations. Even though it's a common practice that LLCs report, a single member LLC might report income to the social of the member. The reg says that you need the TIN of the company, and the social isn't the TIN of the company, it's just who it's attributed to. So does that require single member LLCs to get an EIN? And it's unclear, but it might just be a good practice moving forward. And in general, there's no penalty for over reporting. So if it's in question, if somebody's a beneficial owner, I think our default's going to be report them, because we'd rather have them on the report and them not be a beneficial owner than the other way around and be in non-compliance.
One more kind of issue, we talked a lot about entity formation and ongoing kind of entity specific analysis. We do a lot of M&A work here. A lot of what Jeff and I do on a daily basis is these transactional matters, and this new law is shaping how we view that. So in the M&A space, because this reporting comes with potential liability, it's something we have to be concerned with, right? So the way that we mitigate that is through due diligence. So requesting copies of BOI reports is going to become standard parts of due diligence going forward. There will have to be reputations and warranties crafted to address what happens if there was a failure to comply and there's subsequent liability. And obviously we can deal with that through indemnification. We also want to make sure that after closing, we have the information that's needed. If you're the buyer, that you have the information needed to complete that report. That's going to happen within 30 days, right? It's a pretty quick trigger when you change control in an organization. If there is one kind of silver lining here, that the majority of this concern would be related to equity acquisitions, right? So the asset acquisitions would be less concern, but certainly when you're doing an equity deal, it's going to have to be kind of reflexive to queue up one of these reports and make sure you're addressing the potential risk and liability. And we've talked a lot about this entity formation. I think we can slide past this, but it's definitely, we need to be conscious as we're forming these entities on how to make sure we're complying and setting ourselves up for success with the BOI reports.
And similarly, in drafting trusts, we're facing some of those same issues. Should there now be a requirement for trustees to get a FinCEN ID, or for trustees to be able to hold distributions from certain types of beneficiaries if they don't give the information necessary to go on a BOI report? So something we're evaluating carefully, and there will be some updates to our template trusts as we're crafting these best practices. Speaking of lawyers doing COA, that was our disclaimer that this isn't legal advice, that we are happy to give legal advice to our engaged clients, but that this is general knowledge sharing and information for everybody.
So I looked at the list of participants. We know most of you, and we're friends. So please do feel free to reach out to any one of us. If you have questions on how to work with your clients, if you want to have us talk to your clients, please do contact us. Believe it or not, we love talking about this stuff. So, and we're talking about it a lot these days. So please do feel free to contact us. At this point, I'd like to open up the floor, the virtual floor, to questions. So if you'd like to post your questions in the chat or the Q&A, we'll be happy to take on the questions you have. And in the meantime, I wanted to just note a couple of quirks in the regulations, things that as accountants and financial planners you might be interested in. First of all, there is an exemption for accountants, and it usually is presented in the summary materials or the commentary, or even the information provided by the government. Certified public accounting firms, but not all accounting firms are exempt from registering. So it's only public accounting firms that have registered under Section 102 of the Sarbanes-Oxley Act. So if you're not registered under Sarbanes-Oxley, and are preparing audit reports for publicly traded companies or authorized to do so, then you're not exempt as an accounting firm. That's one thing. Also, we came across. Oh, I think we have. Do we have a question here? I think we do have a question. I'd like to. Can companies see information that has been filed so that they can evaluate whether the information is correct or if changes are required to be reported? The answer is yes. You can go in and view your report anytime you want. The getting, as Matt mentioned, the mechanics of filing are fairly easy. The website's very user-friendly, I believe. And so you can go on anytime you want and easily change your report or your FinCEN registration. There's no reason not to. By the way, all these filings are free. There's no filing fee. So it is very user-friendly. It's once you do some of these, you do 2 of these, you'll be an expert. And you'll start to realize how simple these forms are to fill out. So then we have another question. Is everything filed electronically at FinCEN? Matt, you want to take that one?
Yeah, absolutely. So there is a web-based portal on FinCEN where you put the information in, and there is also a PDF that's available that be completed and submitted. So there's a couple mechanisms to get you there. But yeah, the best practice I think is going to be to go to that FinCEN site and input the information there directly.
Good. Is there a specific form and form number which must be filed?
Yeah, there is a form that you could download. It's not like a standard IRS form. It's more of just a fillable PDF that contains all the same information you would put in the portal, but you don't have to do it via form.
Yeah. And as far as form number, this is not the first accountant who asked me this question. What form number is it? We're not, again, dealing with the IRS. It is the beneficial owner information report. And you can go into the FinCEN website and they'll tell you where to go register. It's a very simple form to fill out. I'd urge you to do it electronically and not physically. But yeah, I think accountants are all going to be saying, what form number is that? Regarding constructive ownership, attributions rule. There we go. This must be an account. Is the spouse of an individual that owns 100% of a reporting entity automatically a beneficial owner based on constructive ownership? That's a great question. Chris, you want to?
My lights went out. I don't think so. I think that I don't believe so. I think that would they could be if they're actually exercising substantial control or acting as an agent, but it's looking to the title ownership of that stock.
Yeah, there is no attribution rule. There's nothing like in tax law an attribution rule. You have to look at each individual and see. It's a great question, but you have to look at each individual and see if they have the authority. This is a really good question. I'm concerned that this filing is going to be forgotten about and required changes won't be reported. Any idea whether FinCEN will periodically, annually, remind companies, beneficial owners to review their information? I saw something just today in some of the materials the government was providing that they really do have an interest in making sure you file this information. And the thought occurred to me, they're probably going to send reminders. Once you are registered now, they are probably going to send you periodic reminders. I have the exact same concern that you have, though, which is that our clients are not going to know. And again, we're talking about very small businesses sometimes. Mom and pop, or maybe just mom or pop businesses that don't, they're not used to filing these kinds of things. They may not even go to an accountant for their taxes. So they're not going to think to do this. So I think as professionals, as advisors, we should all try to remind people periodically, I don't know how often, you know, has there been a change that you need to report? And you as accountants, you're going to see your clients once a year. Certainly put that on the checklist of on the agenda of items to be discussed. Have there been these changes, and go down the list of possible changes? And if so, the form needs to be filed. Yeah, you'll be late filing, but a late filing is better than no filing. And I think, again, I think when the government's looking for willful non-compliance, you're going to be in good shape. But Matt keeps trying to bring this home to all of us. Annually is not enough.
No, yeah, I think that that's the big thing here, is that periodically, unfortunately, doesn't work very well, because a lot of these changes happen completely randomly and sporadically throughout the year. And as we've mentioned, the reporting requirement for a change in your information is 30 days from the event occurring. So it's a really quick turnaround, and these things are tough to predict, right? We can say, look, after you have your annual stockholder meeting, you know, if you appoint new officers, let's go ahead and fill out a report. That's easy. But when, you know, when your vice president moves, or, you know, when a 25% owner renews their passport, like, we don't know when that's going to happen. There's no way to track that, or it's just not predictable enough.
Yeah.
But yeah, we have the exact same concerns, that this isn't going to be done, and the updates aren't going to be complied with.
I believe I've hit all the questions, and we have hit our 3 o'clock time. So folks who need to go are free to go, but there was one other exemption I wanted to talk about. Actually, we could talk about, there's 2 exemptions, I think, as Matt indicated, that are really important. See if you are a large enough company to be exempt. It's the large operating company exemption. And it applies to any company that has 20 or more full-time employees, and employees are common law employees. And full-time means 30 hours, average of 30 hours a week. The company has at least $5 million in gross receipts or gross sales. And I think they're looking at the last taxable year, or any given taxable year. So it's a $5 million a year company with 20 full-time employees. And it has an operating presence at a physical office within the United States, owned or leased by the company, which is physically distinct from the place of any other unaffiliated, place of business of any other unaffiliated entity. This was definitely written by a lawyer. We're talking about a company. There's got to be, the government is looking for a there. By the way, it has to be all 3. It can't be one of these 3 things. It has to be all of these 3 things. So they want to make sure, in order to come under the large operating company exception, that that there's a there. There is a physical operating company space that's not, and I view this as, I'm hoping this is what this means. I hope they come out with more guidance on what this means. But they're looking for a place where people actually work, where the operations of the company are actually located, not just a mail drop. But if you look at the literal language of this exemption, it would preclude a company who is maybe subleasing space from another company. It could be read that way. I don't think that's the intent, but I think this is where these exemptions need to be viewed very, very carefully to make sure they apply, because this covers a lot of companies. A lot of your clients are going to, and our clients are going to fall under this exemption. They're going to want to take advantage of it. So does anybody else have any thoughts on this exemption? We're just waiting. I think we're going to wait for more guidance.
Yeah, and it's the physically distinct part of it that's been tripping us up, and I think tripping some other practitioners up. Do WeWork spaces, does operating out of a WeWork type space automatically disqualify you from falling under that exemption?
Right.
Yeah, and
Maybe.
Jeff, one component that you discussed there was that to meet these tests, many of these tests, there's a lot of elements, and all of them, for many of the exceptions, need to be satisfied. If one doesn't, it fails, and the analysis needs to be done on an entity by entity basis. So, you know, a lot of our clients will have these more elaborate corporate structures where they may have one entity that houses operations, another entity that brings in revenue, and they may have a total organization that satisfies all those tests. But if an individual entity doesn't satisfy all three, then they could be a reporting company, even though the broader company wouldn't be.
Right. And Matt, maybe you could speak, and maybe you could talk to this other exemption for inactive companies.
Yeah, so that's another one that will be, utilized a lot. It's another one we have to be really careful when we're looking at the statutory kind of construction. It's not just a business that's not doing a whole lot. Trying to pull up the definition as we're talking right here. So to be a dormant company, an inactive company, first of all, it has to have been in existence before January 1st of 2020, right? We're going all the way back kind of in the pre-COVID, Stone Age, it feels like at this point. So if you formed a company in 21 and it hasn't done anything, it wouldn't qualify under this dormant company exception. It also, even for companies that are older than January 1, 2020, it can't be engaged in active business. It can't really hold any substantive assets either. So even if it's just sitting up on the shelf with some money in a bank account, it may need to require reporting. We could have a lot of really old entities just floating around out there that people haven't thought about in quite some time that technically need to file reports. And that's where it gets scary. It's one thing for us to advise clients who are coming to me tomorrow and saying, hey, I want to form this entity. Well, it's easy to get them up to date on these developments. It's easy to help them file their initial report. We're worried about these historical entities and how well-versed they are in this and thinking it's not going to apply. And as Jeff mentioned, sometimes you see these definitions that'll say things like public accountant or inactive company or a large company, and they'll automatically think, oh, well, that's got to be me. Well, it requires a little bit of analysis, and that's where we're happy to help perform that analysis, but that's where this becomes a challenging endeavor, is performing that analysis on whether you're exempt and who is your beneficial owner. That's the devil really is in the details here, and that's where we have to dig into the weeds and really do a kind of line by line look.
Right, and I believe we haven't looked into this further, but I believe at least in Maryland, if a company has been forfeited, it's gotten stale and it is now forfeited, I would assume that company does not have to comply, does not have to register, because it is no longer an entity under Maryland law. So we probably need to look a little further into that. Don't take that one to the bank yet. But I agree. I think these older companies that have gone dormant are troubling. So that really brings us to the end of one more question. Discuss the details of when a co-trustee or a trustee of a trust must register. Discuss the details of how to get an identifying number so you can use that when an entity must register. Before Chris answers that question, I would just like to say that, and it came up in, I think you saw it in the chat, we will be sending slides out of the presentation and some other materials, so keep your eye out in your inbox. And also, we will be having future webinars on other topics, so we'll be sending out information on that too, hopefully in the near future. So Chris?
Sure. So the trustee registration is whenever a trust would otherwise qualify as a beneficial owner. So that's they've met that 25% equity threshold under that analysis. They're typically not going to be brought in just under a substantial control prong. I don't know why a trust would ever itself just be a director or an officer. That it's really going to be you've done that equity analysis and the trust qualifies. The trustee is a reporting person. The beneficiary might be a reporting person. You'd also have to look at whether anybody else under the document has the authority to appoint, remove the trustee. They might also end up being a reporting person. And then the identifying number that the trustee personally, if I'm the trustee of a trust, I go get my FinCEN ID. I go to FinCEN.gov, I think it is, and put in my personal information, and it'll generate a number. That's the number I give to the reporting company. The reporting company puts it on the report. And one thing to note, these BOI reports, you don't actually put down what qualifies you as a beneficial owner. You're just identifying yourself as a beneficial owner. So you're not saying I'm a beneficial owner because XYZ. It's here I am, add me to the list. So that that's it's interesting that sort of the analysis ends at that point for them, and they're not interested in seeing what your actual nexus is to the company.
Right. Okay, anyone else on the panel have anything to say?
No, thank you
right,
all
well,
for your time, though. It's an interesting topic. It's top of a lot of folks' minds. We're getting questions every single day on this. I'm sure you all are too. And you know, we're happy to help.
Yep. Agreed. Feel free to contact us. Thank you for joining us today, and we'll look forward to talking to you further. Bye-bye.